My name is Ross Pitcoff of Ross Pitcoff Law. We help business owners resolve complex disputes between partners, shareholders, and third parties in order to give them a better life. Today, I wanted to talk to you about the 4 steps that you can take to resolve your complex partnership dispute with your business partner. Your business is your livelihood. It serves as the purpose for what you do every day of your life. But when things are not going well with a business partner of yours, things can really crumble. Your entire ethos starts to shake. You have issues with what's taking place day to day in the company, and profits tend to go downwards and clients tend to diminish. So now, I want to address with you 4 action steps that you can take so that you can avoid one of these awful situations or at least put yourself on a path to resolve it. Step 1. Go to mediation to try and mediate your claims. Mediation is an informal process where you select a neutral mediator or somebody like a retired judge to oversee what's taking place between the parties. This mediation is non-binding, meaning that it doesn't mean if a mediator makes a recommendation that anybody has to follow it. Mediation is a quick, cost-effective process to try and resolve claims very quickly. Generally, when you go to mediation, each party will set forth a list of items of what they believe took place, and they'll also provide a list to the mediator of what they'd like to see as an ideal outcome. The parties, their counsel, and the mediator work together for a day to see if they can resolve disputes. Step 2. Demand a buyout. In this instance, you're setting forth a written demand to your business partner that you want to be bought out from the company. Or in the alternative, you can make an offer to buy out your partner. If you have a company operating agreement, check its terms because it may speak to what needs to be done in order to complete a buyout of one of the partners. Also, it is most of the time recommended that an accountant or CPA perform a valuation to determine what the fair market value of that buyout should be. Number 3, litigate your claims in court. If the conduct of your partner is bad enough and you're not able to resolve claims without court, you can seek judicial intervention. In this instance, you can go to court and often you will be alleging claims of conversion, breach of contract, breach of fiduciary duties, and if the conduct is absolutely awful and recalcitrant, you can even assert claims for fraud. Number 4, you can file a petition for dissolution. A petition for dissolution is different than a regular filing because you're telling a judge that the business relationship is so awful, so broken down, and is not working out to the point that we want the judge to ultimately order that the company be sold, the assets be liquidated, and the company no longer actually runs. In these types of scenarios, it's not unusual during the process of liquidation for the parties to wind up agreeing to a resolution whereby one of the partners takes ownership of the company and the other partner winds up getting bought out for fair market value. In this instance, both parties reach an amicable resolution so that the business can continue and it can flourish in a way that it wasn't before, and the other partner that's leaving now knows that they were fairly compensated and can carry on with their life knowing that they reached an outcome that was positive for both sides. If you found this video to be helpful, like, comment, or share it with a business colleague or somebody else that you think would find it to be valuable. If you're ready to put your business on the right track and ensure that it can flourish in the future, or if you're looking for a departure from your company, contact us so we can talk about the next steps as to how we'll be able to give you a better life.